Awesome. Welcome, guys, and welcome anybody who decided to spend some of their time with me in what I anticipate will be the last one of these that I do alone. We're going to start filling that chair next to me in the future, or having somebody that'll appear by video so we can have some conversations. But the interest of today's episode here is going to be around a new case that just came out yesterday that I think is important for everybody to know. And remember that as we do these, the idea is to bring to light certain Supreme Court of the United States decisions that otherwise you may have seen in passing, you may not have heard about, that might actually be some case that actually does impact some of your beliefs, some of your thinkings. Try to keep these as unbiased as possible. We're trying to have some honest discussion into certain cases that involve, at our core, items that come and stem from the Constitution of the United States that impact our lives socially, from a religious practices standpoint. And we're going to be addressing one particular case today, which is the Fulton v. City of Philadelphia. And that particular case is one that came down yesterday, which has to do with kind of religious liberties and free exercise of religion, which is a big deal. And when you talk about religion, we don't just keep it to Christianity, but the ability for any organized religion to be able to practice freely under the free exercise clause that was set about in the First Amendment to the Constitution. So we're going to talk a little bit about that particular case today and some of the impact on what came out yesterday. And remember that the idea here is to present not just 9-0 decisions that we did in the first episode and as we do now, which are good because it's important for everybody to realize that there are core fundamental principles that regardless of what you hear or believe is polarizing, that somehow everything is 6-3 or 5-4, that we're actually in a period of time where foundationally the Supreme Court of the United States has judges in there are justices who at their core will agree foundationally on certain items across the board, as they've done on this case at 9-0, and then we'll just differ on how far-reaching the decision may be and how much it should affect other aspects of the life that are not fact-specific to an individual case. So in future episodes, we are going to be monitoring. We're going to be talking about two cases that one of them I think is really, really cool to watch, which is going to be the Levy-Mahoney case, which involves the 14-year-old Snapchat girl that some of you may have heard about. That decision is going to be coming down anytime here in the next couple of weeks, and that'll be a big deal. That's the young girl who was 14 who made some F-bomb comments on her social media chats, and case law has very little that has to do with freedoms of speech from the protections of students for off-campus activity, because I'm 47. When I was a kid, you could go off campus and say whatever you wanted. And there was no internet, there was no social media, so it was limited to whoever heard me. But now you can go off campus at your local ice cream shop, make a comment, and the school can make a determination that that impacted the safety or their ability to provide a learning environment. And that case will be a really cool one that we're going to follow, because it'll involve all of us as parents as we constantly deal with our kids and what we should or shouldn't have them do, or the limitations on their access to social media, or the constant lessons on what they should or shouldn't be doing with their devices with or without your presence around them. So that's a big one. And we're going to be following that, as that young girl was suspended and was sanctioned by the local public school and her parents, as would I, have gotten so upset that it's actually made it all the way to the Supreme Court, and they're going to take that case up. So that's a big one. And there's also going to be one on immigration that we'll talk about a little bit at the end. So let's talk about specifically what we're here today for, which is that Fulton v. City of Philadelphia, which involved a 9-0 decision from the court. So they all agreed. Now, granted, some of them agreed that it should be much more expansive, right? Kavanaugh, Justice Barrett, that agreed that the decision that was made was much more expansive than it should be. And let's talk about first and foremost what this case was about. This case involved CSS, which was the Catholic Social Services in Philadelphia, which was a local Catholic organization that has been around for over 50 years. And as part of its mission, they handled a certification in contract with the city of Philadelphia to vet essentially foster parents, which can be rather extensive. It involves mental checks. It involves home visitations to basically make sure that a couple prior to them taking on foster kids that the state has within them, that they're going to a good family, that they're going to a family that has been vetted. So the local city of Philadelphia, under state law, contracts with local agencies that essentially provide these certifications to make sure that they're ending up in a good home. So as you can imagine, though, CSS, which is a Catholic Christian organization, holds the religious belief that marriage is a sacred bond between a man and a woman. And that certification of a prospective foster family that is the same sex is an endorsement of their relationship, which the CSS will not do as a result. So they've actually never even had a gay couple at any point in time even apply for certification with CSS, but there are more than 20 other private agencies in the Philadelphia area that contract with the city of Philadelphia that provide that service. So what the city of Philadelphia was basically doing here was saying, listen, even though we have more than 20 private organizations that will certify a gay couple, man, woman, to be appropriate foster families, since you won't do it, we're going to prevent you as a Catholic religious organization from being able to certify anyone, even in a traditional man-woman sacred bond marriage. And CSS turned around and said, we're going to fight you on that. And we should be able, under our religious beliefs, to decide that we do not want to certify something that essentially goes against our mission. Now, as I just said, no same-sex couple has ever sought certification from them, and there were other private agencies. So when the city decided to do this, they were really kind of setting them up for this challenge, which at the district court and the appellate court level, they sided with the city. And here we have the Supreme Court in a 9-0 decision reversing that finding, and liberal and conservative justices alike agreeing that here the city of Philadelphia simply went too far. And when we talk about the First Amendment, it's important to note that obviously part of the Bill of Rights that was so important as a foundational principle, that religious practices be available for everyone to be able to undertake. And here what the court found is that this restriction from the city of Philadelphia violated the free exercise clause under the First Amendment, that they could not prevent the CSS from saying, listen, we're happy to go ahead and certify a traditional man and woman to come and be a foster family, but it goes against everything that we stand for as a Catholic organization, that we don't believe that we should be authorizing these other ones. So finding in part that there were already alternate measures by which a gay couple could obtain the certification, and that there were the ability for CSS to then continue. So it was remanded and it was reversed. And in that particular situation, what we have is I think many of us would believe, an appropriate finding that does still allow the non-heterosexual gay couple to go ahead and get their certification, but at the same time doesn't allow for government to restrict religious organizations from being able to do what they want. So the question was not whether the city had a compelling interest in enforcing non-discrimination policies, but whether it had such an interest in denying an exception to CSS to be able to do what they do. And that, to me, I think was the appropriate holding, and I think many of you would agree. So the last thing on this that I want to talk about is there was a concurring opinion, which for those of you that aren't aware is merely just somebody who agrees, one of the justices agrees, but decides, you know what, I want to go out on my own, I'm going to write something else. And Judge Alito wrote a concurring opinion that was longer than the opinion itself. And in that, he basically talks about the fact that he believes the majority opinion stopped short of where it needed to be, and that we really needed to more expansively address the reality that religious beliefs need to be even further protected, and that this just didn't go anywhere near far enough. And in that analysis that he made, he goes all the way back to the 4th century as far as the first findings of Christian organizations that were helping needy children and were establishing orphanages. And around 1789, going all the way back to the foundational history of the country and looking at the fact that 12 out of the original 13 state constitutions in America had a religious free exercise protection in place. So that's how foundational this was at that time. And for us to have further expanded would have been his thought process to itemize that. So listen, great decision to have followed, to understand that all 9 judges absolutely believe, and this goes across the board when you're talking about fundamental religious practice that isn't just limited to Catholic organizations, as the opinion cites to. It's actually a scriptural mandate for Jewish and Christians to have an obligation to care for needy children. So it didn't just apply for Catholics, but all religious abound. So listen, so that was a good one. I think for purposes of our next podcast attempt to address one of these cases, I told you about that Mahoney decision, which is going to be a great Snapchat decision. We're also going to be looking at an immigration case where we're going to have an immigration expert on here to discuss the impact of a case that was just argued 2 months ago, almost to the day, on Sanchez Mayorkas, which also was a 9-0 decision authored by liberal Justice Kagan. And the holding in that case was that an individual who entered the United States unlawfully is not eligible to become a lawful permanent resident, even if the U.S. has granted that individual a temporary protected status. So that's a cool one on immigration that I think is important for us to analyze and take a look at. So little insight into some cases that will come about next year is there will be 2 big cases on gun rights, one called the Corlett case, and there will also be one on the abortion ban in Mississippi, which everybody will be following. Of course, the media will follow those 2, I'm sure, extensively, and you'll hear about them, but those aren't likely to come up for at least another year. So thanks, guys, for the time today. I hope this was a knowledgeable little kind of layman's always explanation into this. And please feel free to email me at aalmazan@almazanlaw for any kind of topics that you want to discuss. We will be moving off of Supreme Court cases once this session is over and start tackling a little bit more of some cultural legal issues that are in need of some in-depth, honest conversations filled with integrity. And I hope that we'll be able to achieve that for you. So in the meantime, thanks for watching All Rise. Thanks for listening in. And we wish you guys all a wonderful rest of your day. Thanks.